One of the questions we get pretty regularly is, should you have a will or a living trust in Georgia? Hi, I'm estate planning and probate attorney Joel Beck with Peach State Wills and Trust, and I'll answer that question somewhat in today's video. So our question is, should you have a will or a living trust? The answer really is it depends, but let's break it down a little bit more. So if we think about a will, most people are somewhat familiar with that concept. A will is a written document that says where things go when you die and who's going to be in charge of that process. We call that person your executor or your personal representative. Now, a will is a probate instrument, and what that means is when you die, your will is going to be filed with the probate court and go through this process that's overseen by the probate court. Well, the court will determine if your will is valid, admit it, officially install your executor into office, give him or her powers and authority to go manage the estate. And what your executor will then do in this probate process is to marshal together your assets, determine what bills need to be paid and pay those, and then distribute the rest of the assets to your beneficiaries in accordance with what the will says. The probate process invites challenges to it, but if it's not challenged, the process is pretty straightforward. One issue, though, that does come up is dealing with unknown heirs or with heirs who don't cooperate. An heir is simply a person related to you who would inherit if you died without a will. So they have to be given notice of the filing of your will. And so if your heirs are not known, perhaps you're not married and you don't have children or grandchildren, your heirs are going to be some other relative. If the folks trying to admit your will to probate don't know who these people are, they're going to have to undertake to do an heir search to try to determine who's your closest relatives, who's your closest family, your heirs at law who would inherit, and get notice to them of the filing of the will. So that can add some time and delays, some cost associated with the process. The probate process is public, and records of the case can be publicly available from the probate court. As I said, in Georgia, the process is generally straightforward, but it's going to take some time. Generally, we're going to see a minimum of 6 months, and that's if everybody is going along and getting along. It might take much longer to settle the estate if people are fighting or if you have a very complex estate, and it's going to be more challenging to get things handled. A living trust, on the other hand, when used properly, is going to avoid this probate process. In that case, following your death, a successor trustee comes in, starts to manage the trust, pays off your bills, and then manages the assets in accordance with the trust, whether that's distributing it to loved ones or holding it in trust for them further. This process only works well, though, when you actually put your assets into the trust during your lifetime, or the assets come into the trust by other means following your death, such as through a pay on death or a transfer on death beneficiary designation. A living trust is going to cost more to set up initially as compared to simply just creating a will. But it will save time, energy, and can save money later on following your death by avoiding that probate process. But a living trust almost certainly saves the family frustration, as nobody enjoys going through the probate process. Many family members find that process to be very frustrating, especially if they have needs and need some immediate access to the assets that are caught up in probate. Now, there are some situations where a living trust really makes a lot of sense, and we're probably going to recommend that as a go-to plan. Here's a couple of those situations. First, I'd say if you have real estate in multiple states, a living trust usually makes a lot of sense because we can avoid multiple probate cases in every state where you have assets if you've used the trust correctly. Second, consider maybe a blended family situation where you want to ensure that assets are available to help care for a surviving spouse, but then if it's not used for that spouse, they're going to be safeguarded and passed on to your own children after your spouse passes. A trust can be a great tool for that. Third, if you have a goal of avoiding probate, have a goal of making things as easy as you can, keeping things private and getting the estate settled as promptly as possible, a living trust may be a very good tool to accomplish that. So when we think about should you have a will or a living trust, I said the answer depends really, and ultimately whether you would be best served by a will plan or a trust plan is going to come down to a lot of different factors. What types of assets you have, where they're located, and of course, what your particular goals are. Once we review that information with you, we can then explore your options, discuss how a will would work, how a trust would work, what other tools might be appropriate, and how that would work. And then you can make an informed decision about what works best for you and your family. Now, it's good to get some basic information about estate planning so you can make some key decisions. And if you're watching this video and looking at some of our resources, you're obviously doing that. But let me encourage you, don't get bogged down doing too much research that you simply procrastinate more and don't take action. Too many people simply fail to get a plan in place, leaving a mess behind for their family. We can help you move from procrastinator to protector of your family with a simple call. Give us a call or visit us online at peachstatewills.com and talk to us about how we can help you with your estate planning and get that checked off of your to-do list. For more information, visit us online at peachstatewills.com or call us at 678-344-5342. Thanks.